Good evening, everyone. Thank you so much for joining us. I'm Rachel O'Shea, zoning planner with Plain Zoning. With me is Will Hager, Planner 3. And this evening we have another one of our public forums to review a couple of articles of the draft zoning ordinance.
Okay, thank you, Rachel. And my name is Will Hager, and I'm a planner with the Department of Planning and Zoning that's been helping out with the zoning ordinance update. And before we get into the focus of tonight's forum, I just want to go over a brief timeline on where we are in the process and how we got here. So staff prepared a draft zoning ordinance to bring the zoning ordinance into compliance with the current comprehensive plan. The draft zoning ordinance was made available to the public in May of 2023. Joint work sessions and public forums have been held monthly to review articles of the draft zoning ordinance and will continue through May 2024. The website you see linked here, the Calvert County MD.gov/zoning ordinance update. You go there to access links to draft articles, the draft zoning map, and to find out where to send public comment, and you'll also find other supplemental materials. And so the focus of tonight's forum is going to be draft articles 1, 2, and 29, title, purpose, and applicability, definitions, and signs. And compared with past public forums, this is going to be a relatively brief presentation. So there's just not as much material to cover in terms of proposed substantive changes in these three articles in focus tonight. But with that being said, we'll begin with Article 1, title, purpose, and applicability. And this article addresses title and statutory authority, the purpose and application of the zoning ordinance. It includes transition rules, such as policies for building permits and variances issued prior to the adoption of the updated zoning ordinance, as well as pending applications. Additional authorities like the authority to create and require the completion of application forms, checklists, rules of procedure, and policy statements, and design manuals and design guidelines, and exemption from permit requirements of the ordinance for maintenance of public utility lines and easement areas, and separability. And so one thing that was revised in this article was the purpose statement in section 1-2, which now states, this ordinance is intended to serve the following purposes: to execute the powers authorized to Calvert County by land use article of the Maryland Annotated Code, to ensure that the vision set forth in Calvert County's comprehensive plan is implemented by land use regulations consistent with the goals set forth, to promote and protect public health, safety, and welfare for current and future generations, to preserve and enhance neighborhoods, to preserve, protect, and promote the county's employment base, to preserve the county's natural and cultural resources, and to preserve oversight and planning to sustain the healthy growth of the county's town centers. And on the next few slides, we'll highlight some provisions that have been added to the applicability section. But before I do so, I just want to clarify that these may be new to the ordinance, but they're essentially reflective of policies that exist today. They just haven't been codified into the ordinance yet. And so, relation to private agreements, this ordinance does not nullify any private agreement or covenant. However, where this ordinance is more restrictive than a private agreement or covenant, this ordinance controls, the county will not enforce any private agreement or covenant. Relation to town center zoning ordinances, if a town center zoning ordinance does not address a requirement, condition, or issue which is addressed in the zoning ordinance of Calvert County, the zoning ordinance of Calvert County applies. However, with the exception of Article 18, the provisions of the zoning ordinance of Calvert County are subordinate to any applicable town center zoning ordinance. And the reason for that last statement is Article 18 includes the use charts and conditions for both districts located outside town centers as well as districts located inside town centers. and relations to other laws and regulations. Unless otherwise specifically provided, this ordinance controls over less restrictive county or state statutes, ordinances, or regulations, and more restrictive county or state statutes, ordinances, or regulations control over the provisions of this ordinance. When this ordinance refers to another statute, ordinance, or regulation, it refers to the statute, ordinance, or regulation as updated or amended from time to time. And relations to previously recorded plats. Any requirements recorded on plats prior to the adoption of this ordinance supersede any conflicting requirements of this ordinance, with the exception of remaining density. And the reason for that last statement being included there, there have been a number of downzonings related to residential density over the years. So if there was a plat recorded in the, say, the 90s or the early 2000s, for instance, that says a parcel has X amount of lots that can still be created through subdivision, that note would be superseded by the density regulations of the zoning ordinance currently in effect. But if there were, say, setbacks recorded on that plat that conflicted with the ordinance in effect at that time, then it would be the setbacks recorded on the plat that would apply.
Which plat? The old plat or the new plat?
Well, it would be, if there was a new plat being created, then the current ordinance would be applied. But if there was an existing plat that was created under previous regulations,
That
the setbacks would be that on the plat would be still be applied.
Plat. Right,
Correct.
on the dated plat, right? The one that
Yes.
Okay, gotcha. I'm with it. Thank you.
And Article 2, definitions. The terms are listed and defined in Section 2-3. Roughly 200 terms have been added, roughly 85 have been removed. I'm sure by the time we get through this process, those numbers will have changed some. So terms relevant for measurements and calculations are included in Sections 2-4, and diagrams which illustrate select terminology have been added to that section. Some definitions have been revised, some to correct flawed wording, others to update based on changes made at the state level, specifically, I think, mostly critical area there. And so one example of a definition that was revised due to flawed wording is a common access drive. So in the current zoning ordinance, that was defined as an access area measuring between 50 feet and 75 feet wide by between 50 feet and 75 feet long, commonly owned by adjoining lot owners, created to provide access to lots. In the draft, that's been revised to an access area created to provide access to lots commonly owned by adjoining lot owners, but may also be owned individually. And so I think the issue that staff had there with the way that was defined currently is that it didn't make sense to include a specific 50 to 75 feet by 50 to 75 feet area as part of that definition. And another example, phase development. In the current zoning ordinance, it's defined as commercial development of a recorded lot or parcel in a town center, employment center / town center, light industrial, marine commercial, or rural commercial zoning in which one specified area of the site is developed before other areas. And in the draft, it's been defined as commercial or residential project that is developed in stages and not at the same time. A plan to show the sequence and phases of development is approved by the necessary reviewing agencies. And I believe staff didn't like the current definition there for phase development that limited the term to strictly commercial development in specific zoning districts. And here, this is an example of a definition revised to bring it in line with revisions that were made at the state level. So in the current zoning ordinance, it's defined as any marine structure generally referred to as a pier, dock, or wharf, including pilings and other such facilities used for wet storage of watercraft. In the draft, it's defined as any marine structure generally referred to as a pier, dock, or wharf, walkway, breakwater, including pilings and other such facilities used for the wet storage of watercraft. It does not include any structure or on pilings or stilts that was originally constructed beyond the landward boundaries of state or private wetlands. And on this slide, one of the more substantive revisions of these three articles relates to building height. So in the current zoning ordinance, a height of 50 feet plus the roof is permitted for non-residential development in the residential district, the light industrial district, and the employment center district if the property is served by a water supply system which is capable of providing adequate supply for fire protection, is certified by the agency providing fire protection, and is in compliance with Article 38.8 of the Annotated Code of Maryland. In the draft, outside town centers, no building or structure shall exceed 40 feet plus the roof, except those buildings or structures listed as exempt in items 2 and 3, which includes things like chimneys, steeples, flagpoles, etc.
Let me ask you, I'm sorry to do this, what is RD 1-1?
So that's RD, that's just residential district, that's a comma, and then I1 is the light industrial
Oh,
district.
it's not. I will.
Yeah.
Oh, I'm sorry. Okay, that's my fault.
So Article 29 is signs, and it includes general provisions for signs, a list of prohibited signs, signs permitted without a permit, regulations for permitted signs, and regulations for permanent freestanding signs, regulations for building signs, regulations for electronic message centers and router boards, and regulations for master sign plans. Master sign plans allow for additional signage for large-scale developments and allow for creativity and flexibility in establishing a cohesive and aesthetically pleasing overall design of signage within a development. It includes regulations for portable signs and regulations for temporary signs. And so the provisions of draft Article 29 are located in Section 6-8 of the current zoning ordinance, and Section 6-8 of the current ordinance was updated in 2018, and that was a multi-year process that a lot of work went into. And so because the provisions for signs were updated relatively recently, minimal substantive changes have been proposed to Article 29 at this stage in the process. Now, that's just for this stage, and the draft revisions may be made to this article for the next draft, depending on feedback received from the public and from the commissioners. But as far as the May 2023 draft goes, the following is really the only revision of substance that was made to Article 29, and that is the following provision has been added. Signs will be removed when the circumstances leading to its erection or installation no longer apply. And so, in summary, Article 1, we have provisions added to address the relationship between the Calvert County Zoning Ordinance and private agreements or covenants, previously recorded plats, the Town Center zoning ordinances, and other laws and regulations. Article 2, some definitions have been removed, and a number of definitions have been added to the draft. Some definitions have been revised, and a new section has been added focused on terminology relevant to measurements and calculations, and illustrations have been added to that section. And Article 29, because the provisions for signs were updated relatively recently, minimal substantive changes have been proposed at this stage in the process. So, I said it was going to be a brief presentation, and I think that probably was the fastest. So I think that we are ready to take some questions if there's anyone out in the audience who would like to step up to the microphone, and we'll also take some questions from anyone listening virtually as well.
You're going to take virtually first?
We can do in person first and then virtual.
Myra Gowans, and I'm asking a question on behalf of Calvert Citizens United, and it's about the definitions. And can you help me understand the definition that talks about the sex entertainment club down in the industrial park? And I didn't realize it was going to be exactly that part of the meeting this evening, and I apologize. But the definition applies, and I have talked to Judy about it, Judy knows what I'm talking about, Ms. Makel. And can you explain to me why that particular definition is in the code, since this type of club and entertainment and everything is usually not approved in Calvert County?
Yeah, just before I get into that response, for this presentation and for the comparison document, I also forgot to mention, we also did a comparison document that compares Articles 1, 2, and 29 with the current zoning ordinance and highlights substantive changes that are proposed. We didn't cover definitions for uses in that comparison document that have already been covered in the previous comparison document for uses.
Mm-hmm.
But the reason why that use was added was I believe that there was some staff that felt that that's something that we were required to do legally.
I think that was from John Norris, because I talked to Attorney Norris about that, and he said that you all wanted it.
Mary, do you want to?
Oh, no,
So
I'm
everyone can
sorry.
hear me online. So there currently is a use in the Calvert County Zoning Ordinance today, and I forget what the title of it is. I think it's adult bookstores, nightclubs, those types of uses. And it's not permitted anywhere in Calvert County. And it's my understanding, per the law, that if you're going to have a use, it has to be permitted somewhere. So then the first thought is, well, let's take it out. If we take it out, then when you have a use that isn't in the ordinance, you have to do a best fit. So it would be where you would permit any bookstore, and we don't want that, because that would be anywhere. So what we did was put it in the place we thought it would be the least controversial.
Which would be the
Industrial.
park.
Yes.
Okay, well, don't go.
No, sure.
All right, here's the thing. The industrial park is for light industrial and industrial. That category is commercial. That is not an industrial category. So why would we, the citizens, allow or ask the commissioners to allow something that is commercial into an industrial park?
Well, let me check on that, because I think that it might be permitted in the industrial mixed use, which is a new, yes, a mix of commercial and industrial. I've got it open. Just give me 1 second.
Sure, go
And
ahead.
that's a new zoning district for us in the draft, and it's
It's new?
in the draft, yes.
And
Compared, we don't
okay,
have
hold
that
on.
zoning
Let me-
district right now in the current ordinance. We
Okay.
only have the I-1.
Right.
But in the draft, we're proposing to have 3 industrial districts, I-1, I-2.
Within the park down there?
So just to, I've
Within
got
that
it.
park.
So it is permitted in the draft. It's permitted in the industrial mixed use as a special exception use. So it would require a special exception approval from the Board of Appeals.
This to me, let me just state this, because I have gotten a lot of phone calls. Calvert Citizens United has been bombarded. Even people who talk to the commissioners have come and talked to us. And they're very confused and concerned about why we would do that in our industrial park, and why we would invite, even under, appeal to the board, that would be something that we would promote in this family-oriented county. So I just want to make that a part of record. That's what I want to do, is stand here and assure you that the citizens are very concerned about this, and their concern is not ebbing. It's getting more serious, okay? Just to let you know, Will, all right? Okay.
Well, we appreciate it. Thank you.
The fact that industrial park down there, that's access to those homes down there along the river.
Oh,
Is
And the
that
children.
right, there are
Which one?
mixed use,
the one that's down?
231, as you go
Yes.
over to Benedict.
Section of the 231 industrial park is will be the mixed use.
Okay, well, I just want to let you know, there is a subdivision back there, a residential subdivision contiguous, and they have to drive through that area to get to their homes. And they have young children and everything back in there. So I just want to make these things, give it to you for your knowledge, and see if there's maybe some other direction that we should take to start this type, because we have other industrial parks in the, you know, in the county, and you wouldn't want to see this thing get promoted everywhere, okay?
It's also an exit to Howling Point.
Howland Point Park, for all those ball games and everything, that exits through that
Yeah,
industrial park.
It'd be good
I was
practice.
gonna say, we can just pass it around. Okay.
Hi, I'm Sue DeZurek, and I'm for myself this evening. So my concern also is that industrial park is the exit for Halloween Point Park. And all those children's ball games down there and stuff are gonna exit through there. And now you're going to have adult entertainment possibilities down there?
Well, I would like to clarify, it's not just going to be outright permitted in all of our industrial parks. It's a special exception use. So if it would be something that somebody would to bring to the table, they would have to submit an application and go through the Board of Appeals process, where their case would have to be heard, and it would have to be approved through that board. So
Okay,
it's
now-
not outrightly permitted.
All right, so isn't planning and zoning gonna help out with the docket for the Board of Appeals now? Aren't you all going to be?
Staff writes a staff report for the Board of Appeals
Now-
based on the application.
So we staff the Board of Appeals. We do their agendas. We do a staff report, which is very, we don't take a side. We give them the information that's provided. Someone makes an application, and then it's a lay board that makes the decision. And every adjacent property owner gets notified, and it's a public hearing that gets advertised, so all of those people could come out and speak against it.
I thought I heard in one of the early meetings, Mary Beth, that now part of staff of planning and zoning was going to be helping out with certain cases that would used to go to the Board of Appeals, but is now gonna be handled
what you're
through
saying.
planning and zoning.
So we have Board of Appeals variances, and we also have administrative variances. Uses are not, cannot be administrative variances. The land use law does not give us permission to do that. So this is a land use
Okay.
variance or special exception.
Yeah,
We
it's
don't
not,
consider
it's not
those
even a variance,
internally.
it's completely different.
Right.
Set of
We-
criteria, it's a special exception, not a variance.
We can do setbacks, we can do parking, like reductions, but not more than 50%. So there's no land use.
And so that's still just in the draft plan, that change?
Yes.
That's not in practice now?
It
It's
is in
coming-
practice now.
It is in
Yes,
practice.
yes.
How long has that been in practice?
Oh, gosh, 2009, 2010,
Okay.
yeah, somewhere in
you.
that range, sure.
And you can make some control by which I subgroup it's in too, right? I mean, you don't put it, you can put them like in a back corner or something.
We're definitely going to take a look at
Yeah.
it. We've heard the concerns, for sure.
A lot of mothers here, I think they understand.
Well, if, is there any other questions that anyone in the audience with us tonight
Here's
had?
a
Bob,
big surprise.
go ahead, step up.
It's not as easy as the one that the commissioners have to raise it up. I'm Bob Estes, asking questions for myself and anybody else that's listening. I noticed in the terms that were taken out, oh, thanks. It does look painful, doesn't it? That'll work. Anyway, thank you. There was a term dealing with senior housing. I think there's a few of them. They were age-restricted housing that we're taking out, but I didn't see anything similar added. Now, maybe I just didn't go through your red list.
Yeah, that's, that list of things, we're going to review that to make sure if there's any terms that we took out that they were taken out for reason. or if it's just something that got lost in the shuffle. And
I'm assuming somewhere in the vast ordinance, there's some, talk about what is effectively age restricted or age preferred housing and that sort of thing.
yeah, there is a section in Article 25 that talks.
I knew it. I was thinking 24, but no.
And yeah, I think that there are provisions in there that speak to what you're talking
Yeah,
about.
I'm just curious what it's called now.
The actual section.
No, what the term is. If we're not using age restricted or age preferred or age, are we going to call it senior housing or senior?
I don't
this?
recall us changing that term, so that's just another. That's something that we'll have to check and make sure that those terms are terms that were taken out for a good
Okay.
reason. And I think the terms that were taken out, I think there's just a lot of terms in the ordinance currently that just that were added without checking to see if those are terms that are actually used in the ordinance.
Sure. Well, you're
And
just
so
trying to
it's-
get things consistent again, and
Yeah, so I think, and it's one of it's kind of a little bit of a tedious process to
oh yeah,
do that kind of search. So it's something that I think will probably be held off until closer to the end. But it's something that we'll definitely do is to make sure that if there's a term that is in the ordinance, that it has a clear definition. And if there's, terms that are in our list of definitions that are just taking up space and cluttering the list of definitions that we don't really use in the ordinance, to take those out. So that's really what we're trying to do.
There's no policy change necessarily. It's just
No.
Okay. Well, I was a little bit worried, seeing how some of us are getting older. Well, everybody's getting older, but some of us look like it. I was looking at the building height. Now, probably I'm getting into the portion of the ordinance that this discussion belongs somewhere else. But after seeing the sorts of things that the appeals group allowed, and I spoke to this the last time there was a big meeting here, it seems like that heights and setbacks and things like that are always changed or amended to favor not the vibe of a community or the neighbors next to these things, but to help whoever's building get a little more, a little more room to build more or to make units bigger. And it just seems like the neighbors ought to not just, they almost ought to have a vote in this thing, not just come out and protest that, you're gonna build some, god-awful 3-story building next to a mom and pop sort of a place. It just doesn't look good. I mean, when they showed us some of those front views, I'm like, that looks awful. I mean, and who controls that? It's a question, and perhaps that's not what you wanted to talk about tonight, but it's still a question and a concern. I think a concern, I heard a lot of grumbling, not people coming up and talking about it, but a lot of people like, well, I know Mr. Gadway, for instance, he's like, you're gonna ruin Solomon's. And it's one of the reasons people come to this county, as everybody knows. So I don't know if there's anything you can do.
I would say that is part of the reason why we do have the architectural review committees and at least for the town centers. And we struggle on a regular basis trying to keep those committees staffed.
Well, I
So-
know you haven't had, I don't know, have you had a real one that hasn't gone to staff? Solomon's did, yeah, of course, but I mean, let's just say that after seeing some of the actions that have been allowed, the public isn't necessarily all that confident in their decisions. And maybe there needs to be a check and balance in there somehow built into this. Just saying, I don't know how you protect, the vibe of Solomon's. I don't know how you do it. Maybe you guys know how to do it. I wouldn't know what to say, but it's a concern.
Thank you.
That's all I got. Lucky you.
Are there any questions from anyone attending virtually?
I don't currently see any hands, but I would like to voice the option for them. If anyone online virtually via Zoom would like to ask a question, please raise your virtual hand so that I can call on you. No, no hands are seen, Will.
Okay, thanks, Chris.
You're welcome.
Okay, I think with that, we're ready to wrap things up. And so I just want to mention that our public comment period for Articles 1, 2, and 29 is open through February 23rd. So get those comments in by February 23rd if you'd like to have them reviewed by the commissioners before the work session scheduled to review these articles. Our next public forum is scheduled for March 14th. And you can see where you can submit comments, zoning ordinance update at calvertcountymd.gov. And if you have any questions, you can contact myself or Rachel O'Shea. And I believe that's a wrap.
Thank you guys for coming
Yep.
out.
Thanks, everyone.